Okay, good morning. Can you hear me? Hi, Mike. How are you? Okay. All right. Can you hear me? Yes, in the back? Okay. Okay. All right. Everyone's making their way in. I'm looking, here we go. This was the picture I was looking for yesterday. All right. So, you can stare at this while we talk about other stuff. First of all, good morning. Brief commercial. Let's see if I can find my commercial materials. Did I leave them upstairs? All right. I left it upstairs. The Center for Japanese Legal Studies is having an event today after our class in room 546 on the law and economics of Japan. And I encourage you all to attend. I don't know if they would be happy about that, since I think it's a small room, but I think you should all come if you can. Japan is an interesting case to think about and look at because they provide somewhat of a counterfactual to the U.S. in many respects. The securities market in Japan, the state of affairs from a corporate law and corporate governance standpoint are really interesting comparative points to look at. Unlike China or other large countries, Japan was always sort of very technologically advanced and had a culture of innovation. It's always helpful to look at how some of the ideas that we're learning here with a focus on U.S. capital markets may be playing out in other countries. So we have a guest visiting faculty member who is here for a couple weeks. And I strongly encourage all of you to go. I think in general, one reason it's helpful, and this will link to our conversation of the Benston article that you did not read, but I will tell you about, is that when we talk about what the securities laws are doing, the 33 and the 34 Act, it's helpful to keep in mind that some of these very abstract conversations we're having about what information does to markets are actually empirically testable. That is, they yield hypotheses that you can go to data and test and see if, in fact, any of the stuff I'm telling you it bears out in the data. And so we will dive into that here in just a minute. But in the case of Japan, one question you might ask is, what can we see about how markets in different countries respond to securities laws as they are passed? And you might, be able to sometimes get an intuition for what the law is doing when you are looking at data and seeing, hey, it turns out that the passage of a particular disclosure rule actually had a specific kind of effect on markets. So I should say that one reason that we're learning the framework that we've been talking about with respect to sort of thinking of how prices may update in response to information is precisely because that framework, unlike the magnitude and probability test, actually yields testable empirical predictions. And to be more specific, you can go back to this two-part test we talked about yesterday and say, in fact, at least with part one, when you see a disclosure law or rule promulgated, or when you see a firm issuing some kind of disclosure, some kind of new disclosure, you can actually test whether or not the dispersion of prices in the market on average shrinks or expands. And Easterbrook, in the paper that I did give you to read, Judge Easterbrook of the Seventh Circuit and Professor Easterbrook of University of Chicago Law School, who is one and the same person, wrote about that in the reading that I suggested you read if you wanted some supplementary reading. And he talks about this study, which I've now put on the board, the Benston study, which was published in the American Economic Review, let's see, in a long time ago, 1970-something, 1973. And what Benston did was actually see if the data support this story that I told you. Is it just Josh telling you that, in fact, if you have more information, that averages don't change? Abir and I were debating this now, 2 classes. How can it be that averages don't change? Is that just something I'm making up and telling you? He wasn't saying that, but we were having this discussion. Is that actually the case? And some of you, some emails that came in last night were similarly suspicious and skeptical of this idea that information reduces variability. And you were wondering how that could be, and is that right? So Benston actually looks at data and answers that question in the affirmative. That is, he finds that the 1933 and 34 Acts, when they were passed, did not change average returns to stock market investing. Okay, they did not change these average stock returns in the market. But they did reduce the variability, or the variance, the spread of those returns. So in this paper, he actually plots and shows you, this y-axis has the word residuals, but that just means kind of the variance that we can't easily explain from other sources, so don't let that confuse you. But he points out, but by plotting this, he points out that, look, actually, both for companies who were not disclosing prior to the 33 Act and companies that did, that's actually what his paper focuses on, but let's just focus on these, because these are sort of your firms that you would be thinking would be most affected by the 33 and 34 Act, right? These are the companies that were not disclosing information to investors. You can read the paper for what kind of information, financial data and other categories that were mandated by the 33 and 34 Act. And what we see is that in the data after the 1933 and 34 Act, the average gains to those portfolios is relatively unchanged, and Easterbrook actually discusses why that is the case. Again, there's an extensive conversation there if you want to read more about it. But the key point I want you to focus on and understand is that you do see that variance shrinks. You see that the spread of returns is shrinking. So this is, if you will, the actual data version of the $9, $11 shrinking to $9.50 and $10.50. Okay? It actually is what the data show, believe it or not. Why is that the case? Well, again, it goes back to the framework we were discussing, that disclosure reduces overpayment and underpayment. It increases information. Easterbrook actually points out in the readings that I gave you that he thinks, at least the data seem to show, that the mechanism by which that happened is that the 1933 and 34 Act pushed out some small firms. And those small firms were very volatile, and so pushing out those small firms reduced volatility in the market as a whole. And that is another way of saying the thing we've been saying all along. That is, how is it, as many of you questioned, that the compelling information shrinks variance from 9 and 11 to 9.50 and 10.50? How is it? Does it kill real-world investment opportunities? That seems strange. There should be still $11 firms out there, right? Well, the technical story behind how exactly this works is a little complicated and requires some depth in financial economics that I'm not going to put you through. I think we've done enough. But if you really want to understand the mechanisms, come talk to me in office hours. But the intuition is that, like we saw in the 1933 and 34 Act, historically, that small firms or highly volatile firms dropped out of the stock market, because disclosure rules were imposed. The same intuition explains generally why disclosure tends to smush the spread of returns. Basically, in a nutshell, you can think about it like by telling everyone more, there are fewer opportunities to both make a lot of money and lose a lot of money. And a small firm is like an opaque firm. It could be very, very successful, or it could be very, very unsuccessful. And so by pushing the market towards greater transparency, you kind of take the opacity out of the market. And so the price at which you can buy and sell gets closer to the true underlying payoffs. And what that does is actually smush the spread of returns that you can make as an investor. All right? Beyond that is beyond this class. So happy to talk to you more about it, but you have to take that on faith. You're not going to be tested on this, that particular point. But I do think what I'd like to see is that you understand the trade-off. Remember, the trade-off between informed trading and disclosure is a trade-off of whether or not we want to put money in the pockets of informed traders, knowing that they will use that money to go out and listen when doing so is costly, or do we want to compel the disclosure of information into the market, which actually smushes down the variability and thus takes away some informed trading profits and hands those profits to noise traders or to uninformed traders. And that tension between how much do we want to give informed traders versus how much do we want to give noise traders, or how much do we want to, like this picture shows, reduce the spread of gains and losses in a market, that's the tension at the core of securities law. That is what securities law is all about. So one reason it might be interesting to look at a place like Japan is because they might have chosen a slightly different balance. You can see how events in other countries play out, and that can be really illuminating perspective on U.S. law. I mean, you could even imagine a hypothetical, not saying this would ever come up on an exam, but it might, where you're being tasked with crafting a new securities law regime for a new country, or maybe an existing country that wants to reform securities law, right? And so having an intuition for these policy trade-offs can be really useful, not just in the narrow sense of litigating specific cases and trying to figure out what the U.S. case law on materiality is. Okay, that is the task that you can easily perform as Columbia Law students. But having this intuition, this well-developed sense for what the trade-offs are in these rules and how certain rules strike a balance one way or the other is not something that necessarily comes via Westlaw research, right? This is the kind of intuition that I want you to develop through looking at the law as we have it in the U.S. and seeing how it's applied in different settings. All right? So let me take a little bit of time in the spirit of making sure the cookie is completely baked and just answer a couple more emails that came through, and then we will move on to forward-looking statements. One of you asked me about the dissent in Texas Gulf. Are we just basically learning securities law as the dissent in Texas Gulf would like us to know? And the answer should be very clear that no. We are not following the dissent in Texas Gulf. The law, so there's no confusion. The materiality standard as it is articulated in Texas Gulf is the standard articulated by the majority. That is the law. It is the probability and magnitude test. But very quickly, we move past that because you're at Columbia, and you know that tests like these don't mean very much. You can easily warp them to any set of facts you would like. And in fact, you'll do that. I'm sure you'll all do it. And so let's just move past that and ask ourselves what is wrong with that test, or where does that test have limitations? And the reason we look at the dissent, of course, is because the dissent has a good intuition for what, oh, here's the cap to my pen. I was trying to, this is great. Dissent has a good intuition for what the majority is not getting wrong, but the limitations of the majority's test. And so what the dissent says in Texas Gulf for the last time is that, we can't put the firm on loudspeaker. And all we're learning from the dissent is that there's a problem with putting the firm on loudspeaker. What is that problem? You remember from yesterday, if you just tell total transparency, the market, everything, a lot of that information is going to increase uncertainty and thereby increase the risk that investors face when purchasing your firm, this information risk. I'm not going to spend more time on that because we beat that horse yesterday. Another one of you sent me an email about cybersecurity, and I think it's a good chance to talk another minute or two about that. So just to remember, the problem that we're facing in the cybersecurity setting is just a classic application of this trade-off, right? Now, what's interesting about this, that is this trade-off between informed trading and disclosure. What's interesting about the cybersecurity setting is that the idea of disclosure seems really tricky to practically implement here. In the Mitz-Tally paper, you see that we are talking about a time period before the firm has any knowledge it has even been hacked. And so one particularly vexing policy challenge here is that it's not clear what could be done. One of you asked me, well, is it, maybe we don't want disclosure of cybersecurity vulnerabilities because that, is bad. It leads to the theft of personal information. It undermines confidence in medical devices. I just want to make sure this is clear. The law did not mandate the disclosure of St. Jude's pacemaker vulnerability. Just nod your heads if this is clear. So there's no confusion on this point. St. Jude, Muddy Waters and MedSec, the two firms who made this deal, announced the vulnerability after they had opened a short position in the stock of St. Jude. The law didn't prohibit, it never does, other than anti-fraud rules. By and large, you're allowed to say anything you want about a company, right? So don't get confused here, right? Just keep it analytically very clear. When I'm talking about the trade-off between informed trading and disclosure, I'm asking, should the law have somehow taken away Muddy Waters' profit from buying, from shorting, from selling St. Jude? Not because there's some choice between remaining silent and speaking. That's the trade-off in the Section 5 setting. But keep it distinct in your minds, okay? So Section 5 is about keeping silent or speaking. But we're out of Section 5 now. We're not talking about the sale of securities under Section 5. We are, at least part of our conversation is about the 1934 Act since last week, right? We're often talking about ongoing disclosure under Form 10K, Form 8K, Form 10K, Form 10Q. And so the question we're asking is not whether there should be some prohibition on Muddy Waters speaking about the pacemaker vulnerability that MedSec found with St. Jude's pacemakers. But rather, should there be some kind of compelled disclosure earlier in time so that Muddy Waters doesn't get to play the role of the informed trader in these hypotheticals? So that Muddy Waters doesn't get to take that profit and use it to fund, right, subsidize the MedSec security research. The question is, do we compel earlier disclosure rather than allowing silence for a period of time, which is the status quo right now? Nod your heads if this is clear. That's the question that's posed by the Muddy Waters hypothetical. Not hypothetical, by the actual story that happened, right? And so one problem here, it should be clear to you by now, that it's very difficult to compel disclosure of information that you don't know, and particularly in this setting, and why this is an interesting setting, I think, it's not clear that the information would have ever been found. Maybe they would have never discovered the vulnerability if they didn't have the opportunity to trade on it. So this is a particularly puzzling case because it's forcing us to go back in time to a moment when nobody at the firm knows about any facts that could be disclosed. And it kind of leads us, I think, to conclude, look, maybe informed trading is great here because it's the only way to bring this stuff to light. It's the only way to tell the world that for these poor, victims, really, you could say, of that is these patients who have these pacemakers implanted inside them, this is the only way to alert them to a potentially life-threatening risk. Now, there's got to be some of you who have hesitations about the idea that handing money like this to hackers and hedge funds is like the only way to prevent pacemakers. Okay, so part of why this is a really fun question is it causes you to grapple with that. Now, can anyone articulate, like, let's see if you can kind of on your feet apply, or maybe you thought about this last night, like why that argument may, like, can you think of a counter argument? I mean, is there a limitation, or do you all just agree with me that, in fact, this is great? We should just, keep putting money in the pockets of hackers and hedge funds. Does anyone disagree, and why? Can anyone articulate a reason why it may not be great to just let this status quo continue? And can you try to articulate that from the standpoint of securities law? This is like kind of what you would do on an exam, right? You would apply the law to muddy waters, but then you would come to a point where you'd have to articulate why disclosure right here would be a good or bad idea, or why informed trading would be a good or bad idea. So can anyone articulate why it is that we shouldn't just let the status quo continue? Let Muddy Waters and MedSec trade, short these kinds of companies, and walk away with the profits. Candace, right? Yeah. So Candace asks, how is this different from insider trading from a policy standpoint? So Candace, it's clear to you, right, how it's different from a legal standpoint. There are no insiders. Okay, so we're on the same page. Well, I mean, the fact that there are no insiders, right, makes this different in some ways from insider trading. One reason we'll get to insider trading in a couple weeks and the policy behind it, the prohibition. But one is just the idea that we think informed trading is not good for market liquidity, and we don't like the idea of letting corporate managers walk away with this kind of cash at the expense of uninformed shareholders. Now that policy argument, though, you'll see is a very weak one under current U.S. law. U.S. law did not, the prohibition on insider trading did not evolve on a theoretical premise of equality and access to information. It evolved on a very different historical basis that we'll discuss concerning anti-fraud liability. The idea that you're perpetuating a fraud on your counterparty when you know something that they don't know. Well, let me say that differently. When you have obtained information in breach of some sort of duty of confidentiality, and therefore your counterparty is entitled to suppose that you wouldn't trade with them in a way that violates your fiduciary duties. But it's this somewhat contorted, convoluted theoretical foundation that is largely a historical artifact of how insider trading law developed, which again we'll break down in much detail later. But that doesn't seem to be of much help here, because the most you can get out of that rationale is this equality of information concern. Here there's no breach of any fiduciary duty. So there's no insider who exploited their informational advantage. And as the Supreme Court has the sort of fruit of the poisonous tree idea, we'll learn, like, there was no sort of continuing breach of confidence that then brings deception into the market. because all the hacker is doing is on an arm's length basis, finding a vulnerability with a firm, learning something about a firm, no different, you might argue, than a stock analyst or anyone else, like a doctor evaluating cancer abstracts, developing that knowledge and then selling the firms that he or she finds are vulnerable. So the policy rationales prohibiting insider trading, the only one that you can probably use here is the general idea of equality of access to information and increased liquidity, but that's the weakest of all and certainly does not serve as the foundation for U.S. insider trading law today. So is there an argument applying the framework we've discussed so far against cyber hacking and trading? Yes. Paul, yes, Paul.
So maybe you could argue that because this is like a really sensitive area and people are very concerned about cybersecurity, if you let someone who has an incentive to try to exploit that information disclose it, so in this case you have the hedge fund and they're interested in having a big splash that involves this information, that disclosure might increase the volatility, and instead of getting closer to a true price, move farther away from the true price.
Okay, so great. So Paul says if we have the disclosure, then if we mandate disclosure, then prices will become more volatile because it'll be harder to understand what that means. But I think you're now agreeing with me that what Muddy Waters, do you disagree? What Muddy Waters did was great. Because remember, the question is not, will we allow Muddy Waters to speak? They're going to speak either way. The question is, do we accelerate or make Muddy Waters say more than they would have said otherwise? And you seem to be saying they shouldn't, that's a bad idea, because that's going to increase volatility. Do you agree that then supports the status quo, that you agree with me? Are we on the same page, same team?
I think you could only argue maybe in terms of framing. So if you have an incentive to have the company itself disclose,
Yeah.
produces less of a splash in the public as opposed to having someone who really wants to increase the public reaction.
Yeah. Okay, so Paul says maybe we should have St. Jude disclose. But St. Jude wasn't even aware of the vulnerability until after Muddy Waters not only had discovered it with MedSec, but had opened a short position. So how would that work here? Yeah, Michael, what do you think?
How Muddy Waters to disclose if they don't have
Well, so that was kind of a question I posed at the beginning. Disclosure seems kind of hard here. But one idea is you could basically tell the Muddy Waters, the hedge fund, you can't trade unless you disclose. So you cannot short, sell. You cannot accumulate any position unless you first tell the market. So you could say that, right? Do you disagree? Yeah. Yeah, so the hedge fund could, right? That would be one approach. It would be similar to what we have in insider trading law. You'll learn, like Candace suggests. Christian, what do you think?
So if information about hacking vulnerability isn't already on the market,
Yeah.
and if some of the tech firms aren't hackable, wouldn't investors have already kind of discounted the price they're willing to pay for that risk? And disclosure would seem to only reduce an idiosyncratic risk at that point. I don't know if that's exactly in the framework that we're talking about, but
Yeah. Yeah, so Christian says maybe it's just idiosyncratic risk, and it's already in prices on average, and so we shouldn't care. So does this really keep flashing on you guys? Yeah. Okay. Let's see if we can. We are currently performing maintenance. The touch panel is non-operational. I love you guys, Amy. This is great. Off. Okay. All right. Sorry, it was just distracting me. So Christian says maybe this is idiosyncratic risk. So in that case, it doesn't matter that you're making investors better off. Remember, we said idiosyncratic risk is risk uncorrelated with consumption. That is, it's like a coin flip. that pays you off in both directions all the time. So it could be that the economy is doing really well, the economy is doing really bad, but in any event, the fact that you know of a company's cyber vulnerabilities just tends to offset. So sometimes, let me say it differently, the fact that you do not know about cyber vulnerabilities at a particular firm, well, that lack of knowledge will lead to overpayment that tends to offset in both directions all the time. That's the meaning of idiosyncratic risk. So in other words, it could be that I'm going to be an investor in St. Jude, and I'm not aware that St. Jude is hackable. But there's another company out there that, like St. Jude, I suppose could also be hackable, but it turns out they're not. And so on average, my losses in St. Jude are offset by my gains in the other company. And as long as I'm pricing on the average of those two, I don't care. Okay, so this is always a good one to bring into your answer, right? Because you always pull out the, like, it's not macro links, right? Okay, that's fine. And it's probably convincing that cyber risk is not macro linked, is not cyclical. Is it not cyclical? Well, so let me throw this out. So you could think that what's going on in a lot of these cases, like in our paper, is actually state-sponsored. So I was talking to a national security expert who was telling me that, you know, a lot of corporate hacking is actually sponsored by, like, state entities, like Russia and others. It could be that they tend to do more of that in a way that's cyclical, like with election cycles. Right? So the point is, you want to be creative about trying to find some cyclicality to the phenomenon. And the more creative you are, you know, the better, right? Because you don't know. I mean, it's a guess either way, but try to find the best story you can about how it's either non-cyclical or cyclical. That's good. Other arguments besides cyclicality? Yes. Zebulon? Yes.
If Muddy Waters doesn't have disclosed, don't they have an incentive to prevent other firms from discovering this information? To invest some money into not discovering this information, which is something the public should be aware about, which would prevent, noise traders, or would prevent people from determining the fundamental value for a longer period of time.
So Muddy Waters, if they do not, if they have to disclose, they will, or
if they don't have to disclose, then they will hold on to their short position for a longer period of time.
Yep.
Which would incentivize them to prevent other traders from learning this information.
Yes, and that's good or bad in your view?
That's bad.
That's bad because so that hurts more noise traders, so they get to capture more of that surplus, right? So you don't like the fact that you just don't like informed trading under that story, right? So or is there something more to this setting?
Well, I think in this setting, especially with the information, the information is socially beneficial for
Good,
people,
right?
for everyone to have this information
Good.
as quickly as possible.
Good. Zebulon's, yes, exactly. Exactly. Let's just make sure we all see this. This is the kind of thinking you want to be doing, right? So Zebulon says, look, there are other benefits to getting this information out sooner. One of them might be just the poor pacemaker patients. The poor pacemaker patients are walking around like they could be shocked at any moment. Like they could be in Publix in Florida. My grandmother's in Florida. You know, they're all like walking around, and then there's some, Russian hacker, terrorist, like, you know what I mean? Like, we laugh, but this is a big deal. I mean, these poor people, like, deserve to know this, okay? I'm surprised it took us this long, because I've, like, indoctrinated you with, like, economic theory. You're like, the last thing you're thinking about is the welfare of these poor patients. But it's true, like, that's an important public policy concern. Yes, I saw a hand, yes, on the left. Right, Sam?
Yep.
Yeah.
So once Muddy Waters has locked in its short position, doesn't it have the incentive to disseminate the information to the market instantly rather than hold on to the information?
Oh, yes. We said that at the beginning. Absolutely. So the information's going to get out, but the point is that the point that Zebulon's making is that if you said to Muddy Waters, you cannot even buy or sell on the basis of this information unless you announce it first. Comparatively, like maybe they would only wait a week in your story. It take them a week to accumulate their short position. But under Zebulon's view, Zebulon's argument is, look, they would be announcing at the beginning of that week instead of the end. Do you find that convincing?
I mean, I don't find it convincing that they would find out the information in the first place if they had to disclose it.
Good.
So.
Exactly. That's the pushback I'm looking for. Now you're sort of, yes, exactly. Now you're thinking, right? They may not disclose. They may not discover it in the first place, because if they can't profit off of it, they won't discover it in the first place. So are we better off in a world where pacemaker patients don't know they're vulnerable? Or, okay. In the back, yes. Joshua?
I'm actually Ben. I usually sit up there, but
Ben.
just
Oh, there you
easier
are,
for
Ben.
today.
Sorry.
I don't have it. I was going to say, I think the reason why we didn't come to Zebulon's point earlier was exactly that the listening is expensive, and so what's the point of them doing that listening in the first place if they can't profit on it?
Good. Okay, good. So kind of talk it all out, right? In your answer. Yes, Elliot.
Yeah, so I think there's a counterpoint to that, which you made in your paper, that maybe you could provide some sort of incentive for Muddy Waters to actually disclose this information, but not allow them to take an extremely large short position, and that kind of straddles the line.
Elliot really read the paper because that was buried in like the last section. So here's another check. I'm just kidding, guys. Come on. Not that corrupt here. Come on. Great. So Elliot says, look, maybe an intermediate solution is we give some profit, but we cap it. All right. So that's our proposal in the paper, is to cap it. I don't know. Do you think it's a good one? Does anyone? What do you think about it? Yes. Sam.
Well, I think you could cut Muddy Waters out altogether, and it seems that there are already programs like this. There's bug bounties in a lot of firms that know they have cyber vulnerabilities, and so if you were to do that, you wouldn't have to deal with the securities market at all, and then you would have potentially faster disclosure. The only potential downside would be that the hacker groups wouldn't be getting as much money potentially, and so perhaps they wouldn't be quite as incentivized. And I think then you'd really need to dig in and decide, okay, is the, say, million from the bug bounty enough to incentivize the level that we would want, or do we really want to compensate them, say, 100 million, and would that lead to more disclosure that would want?
Great. Excellent. Excellent. The combination of all of these is an A-plus answer, right? Perfect. Now you're really getting it, right? So exactly. So Sam says, look, like, you know, maybe we have other ways of accomplishing this social goal. This is always a good idea to keep in mind. Like maybe the securities markets aren't the tool to accomplish the social policy goal. Now, you know, one of the things about bug bounties that I found interesting, and I don't know if we talk about this so much in the current draft, but we should, is that they're often not disclosed, okay? Or depending on the industry, the purpose of the bug bounty might be to tell Google, like, people's email is hackable in the following way. But in the case of St. Jude, it's not clear that, that St. Jude would even pay anything because they hadn't established a program like this. Maybe they think that it's not credible. I mean, the hurdle to establishing the problem is much higher when you're talking about a device manufacturer. So there are some factual distinctions you'd want to keep in mind. But for our purposes, it's enough, I think, to say, look, informed trading isn't the only way to accomplish this social policy goal. One point that none of you brought out, I think, yet, although I talked with one of you about this after class yesterday, is that if you allow a lot of trading like this, and this is true in informed trading more generally, you will give an incentive for more hacking. And there's this bigger question, are we better off in a world with less hacking and less knowledge of vulnerabilities, or more hacking and more knowledge? Okay, that trade-off is a deep trade-off. It's a tough one, right? Because do I want to be blissfully ignorant and view like hacking as a kind of tail risk that 1 in a million times may pop up and explode? Or do I want to know? You know, you can think about airline security, right? Do you want to know about all of the different ways that terrorists might or are planning on or trying to infiltrate our planes? Or do you want to just not know and let the experts kind of filter information before it reaches the public? One of the arguments that you see in industry in this spirit is that more information is not always better. This is true about cybersecurity. I mean, it's their viewpoint on cybersecurity. But it's true more generally in other areas that the idea that more information is better is not always convincing. And Madeline, where are you, Madeline? Hey, how are you? Great email I got before class from Madeline. There's a New York Times article, "Too Much Power to the People, a Food Safety Site Tests the Limits." I don't know how many of you saw this. It's a story about this website. I think it's igotpoison.com or something like that. I've got poison. Yeah. And you basically go in and upload your Chipotle story of how you got food poisoning. And this will forever be the mark on Chipotle's brand, because here it is. In the case of Chipotle, the stock price fell by more than 5% after the website published multiple reports about food poisoning at a store in Virginia. And one of the responses, you would think industry, at least as a whole, or food science researchers, food safety researchers, would say, this is great, because after all, it's going to keep people from getting really sick. But that's not what they're saying. If you read the article, they're saying it's really bad to put that information out there because it's going to scare the you-know-what out of people, and they're not going to know whether the fact that they got sick after eating at 4 places that day, which place actually caused it. It's going to have all kinds of hysteria-inducing adverse side effects. So going back to our framework, this is all part of questions 1 and 2 in this 2-part test. Does the disclosure increase uncertainty or reduce it? You could argue that the disclosure of food safety actually can induce a lot of hysteria and increase uncertainty about what companies are worth. And similarly, you might say, look, this is exactly the kind of setting where we want to prefer informed trading, because we'd rather let a few people figure out the real culprits in the market. We'd rather have a cottage industry of, food poisoning experts out there, food poisoning hedge funds, whose job it is to go search out whether or not Chipotle really is killing all of its customers. And if they are, then those are the traders who should get to profit from shorting those firms. This is just muddy waters transposed to a new setting. Okay? It's very likely something like this will be on the exam. So I want to make sure that you all see it. It's just taking the same facts, just thinking the exact same way about this trade-off. Do we put money in the pockets of people like Muddy Waters or hedge funds to let them exploit their informational advantage so as to induce them to invest in information gathering to begin with? Okay, any questions before we move on from materiality? Is this crystal clear to everyone? Nod your heads. Raise your hand if not. Anything else? Going once. Going twice. Okay. Yes, Davia. No worries. If it comes back to you, we can raise your hand again. So just to recap, we are seeing the same problem present itself in different settings, right? So the Muddy Waters cybersecurity setting shows us the tension between informed trading and disclosure. The food safety setting shows us the tension between informed trading and disclosure. How does it work there? Well, if you disclose, like this website is allowing people voluntarily, notice the law is not requiring this, okay? So that's an important point. What role is there for the law? You think about that. But people are disclosing adverse events with food safety, right? They're disclosing, I got poison, I got food poisoning. That increases information, but it might not reduce uncertainty about what companies are worth. In fact, food science researchers food safety researchers in that article are arguing that it doesn't, that it just induces hysteria. Now, you might think that's a good example. So that's an application of prong 1 of this test, which is that it can increase fundamental uncertainty. As for prong 2, you might think that the right way, for various reasons, which you'd want to articulate, to induce information gathering in this food safety setting is to give it to some informed traders like food poisoning hedge funds, whose job it is to search out the Chipotles of the world, short their stock, and walk off with the profits after announcing a long string of. You could think of like investigative journalism in this way. Should investigative journalists partner with hedge funds, seek out problems in the world, accumulate a lot of evidence while letting the hedge funds, short the companies involved, and then come out with a CNN special, right? Or CBS, 60 Minutes, right? That's another version of the same hypo. Okay, so I think you can imagine similar hypos, and that's what I'm encouraging you to do. One of you asked me, do we need to know, like, your paper? I'm not going to ask you about my paper on the exam, but I will ask you to think of a setting like this, right? A news setting, probably, that will involve these trade-offs. And so the reason why you have the hypotheticals, why you have the reading material, isn't because you're going to get quizzed on the reading material, but it's to get you thinking and so that you can apply this to a new setting. Okay, forward-looking statements. Done with materiality for now. Oh, one of you asked, is Texas Gulf the end of the case law on materiality? No, of course not. We're going to learn basic and matrix, but those cases are similarly unhelpful. They end up all reducing to kind of meaningless statements about reasonable investors and total mixes of information. So this framework will be very useful, but we're going to come back to materiality in the context of civil liability next week. For now, let's talk about forward-looking statements. Forward-looking statements, who remembers, were originally, raise your hand if you think originally the SEC loved forward-looking statements. The companies were allowed to put forward-looking statements from the very beginning in their prospectuses. Raise your hand. No, well done. Raise your hand if you think forward-looking statements were prohibited. They were prohibited. You remember from the casebook reading that historically the SEC took a very anti-forward-looking statements position, arguing that this would confuse investors. What's a forward-looking statement? What is a forward-looking statement, Davia? Projected revenues, exactly. Exactly, perfect. So Davia points out that a forward-looking statement is really anything that involves the future. We project to make 100 million in sales next year. We are confident that our business is strong and is going to perform well in the coming year. All right, you read Beecher v. Abel. Now let's return to law school. And someone tell me the facts of Beecher v. Abel. Yes. Andrew.
So McDonald.
It's on.
So McDonnell Douglas filed a prospectus for securities, and they had a projected income statement for 1966, claiming that it was very likely that net income, if any, for the fiscal year 1966 would be nominal. However, McDonnell Douglas ended up with catastrophic losses that year. So shareholders brought an action claiming that they were that statement was a material misrepresentation.
Great. So, perfect. So, Andrew, what was the issue with the representation? So, walk me through the analysis of when it was true, and let's take the facts as alleged as correct. So, when was it true? And when was it false? Walk me through the timeline of that.
So when they made the statement, it was based on actual projections. And then from what I remember, there were a bunch of macro trends that made their business model significantly less profitable in the intervening time between then and the suit.
Yeah. Does anyone remember what those macro events were?
Well, it was Vietnam War, and they lost a lot of their labor supply. They had a lot of capital issues at the time as well,
Yeah.
right?
So one of them was what war? 1960s?
Vietnam.
Vietnam, right? So some of their employees were drafted, and there was another factor. Yes. Have you? Dylan. Delays in the supply chain. Yeah. So those two factors, delays in the supply chain and the draft, were contributed heavily to the net loss of, does anyone remember how much? 52 million, right? That they had by the end of fiscal year 1966, not the calendar year. Okay. So Andrew, back to you. So what does the court decide about the claim that is being made regarding the earnings projection for fiscal 1966?
Well, they run through, whether the statement was false, misleading, or manifestly material, concluding that it was false because it was not highly probable the company would break even. It was misleading in that it omitted to state facts necessary to make the predictions not misleading, which seems a little tautological. And it was manifestly material since it represented top management's assessment of the company's prospects. So the reasonable investor could rely on it because it was the management saying what the company expected.
So this is kind of interesting, right? Because what the court is pointing to is that's exactly right. They write on page 261 of this, or 146 of the reader, and 261 of wherever this was taken from, I guess another casebook. The court, however, finds that a reasonably prudent bond purchaser would not have concluded from the facts available to Douglas management at the time the prospectus was issued that it was highly probable that the forecast would be satisfied and that substantial losses would be avoided in fiscal 66. So what the court is doing in Beecher v. Abel is something very troubling, I think, if you are a corporation, and saying, look, you can have supply delays, like delays in your shipments of from your suppliers, and you can have a war, draft your employees, and anything you say about what your company's going to be worth, if it turns out to be wrong, even because of events that are completely outside of your control, you are misleading your investors. And that is a violation of the securities laws. In fact, and this is the convoluted language you read here, right? A reasonably prudent bond purchaser would not have concluded from the facts available to Douglas management at the time the prospectus was issued that the projection was right. In other words, the way the court tries to justify it is to say, look, if a reasonably prudent bond purchaser, if a investor had the information Douglas management had, they would have concluded that the forecast didn't make much sense. But the reasons the forecast didn't play out seem to be completely unpredictable to me, at least. I mean, I don't know. Maybe there was some indication that the supplier would have, there would have been delays in the shipping. But maybe the claim is, look, you should have ascribed a greater probability to your employers being drafted. But it's a pretty sweeping idea that Beecher v. Abel puts out there. It basically says, look, if something bad manifests along the way, we're going to ex post conclude that you had enough information and should have warned investors about it. It doesn't make a lot of sense. It doesn't make a lot of sense. It actually turns the firm into a kind of insurer, right? The firm ends up insuring against these risks. No firm can insure against the risk of a war. I mean, that is just completely non-diversifiable. So basically, this is what going to do what? Well, you should have this intuition kind of developing now. Basically means that as an investor, I am just going to pay less for, excuse me, let me say that differently. As a firm, I'm going to expect to receive less because I'm going to have to insure my investors. That's going to take away, essentially, from my ability to raise capital, which means that I will pursue fewer projects because every project is going to have this little tax attached to it, which is I'm going to have to repay my investors if something bad happens. And because I can't buy an insurance policy against the Vietnam War, okay, I am now going to have this ex post liability that whenever something bad happens, I'm going to have to reimburse my investors. That then is a cost I'm going to have to bake in to my profit and loss calculations for any project I pursue. And what am I then going to do? There are going to be some projects that I'm not going to pursue, like those that might be particularly vulnerable if there's a war, or those that require on-time shipping. And so that ultimately hurts all shareholders, right? It actually makes the firm less valuable. So you can think about Beecher v. Abel. I'm not going to spend too much time on this because it's not the law, but just to get the intuition here, this is a kind of redistribution. All shareholders pay to redistribute some. Who's the sum? Well, those shareholders who happen to be hurt at the time that this adverse event plays out. So everyone pays up front. That is, the firm has to charge off, has to put in a separate account, kind of like an insurance pool. And we're going to take from that pool and compensate those who were hurt down the road. By the way, all of shareholder litigation is kind of like this. So we're going to hit this theme over and over again as we move into civil liability. Whenever a company pays money to its shareholders, that is actually a payment from some shareholders, from all shareholders to some, right? It's just a transfer. You all see that. Nod your heads if that's clear. The value of the firm consists of the assets minus its liabilities. And so if you take some of those assets, you take some cash from the firm and put it in the pockets of certain shareholders, you are just taking money out of the pockets of those shareholders who would have received the assets of the firm, perhaps at some point in the future, and giving it to those shareholders who are bringing the lawsuit. We're going to come back to this point. This circularity problem in shareholder litigation is a big one. A lot of papers have been written about it, but that's for next week. Just notice that what's happening with Beecher v. Abel is a kind of insurance policy where essentially if you're a current shareholder or a future shareholder, you are on the hook to reimburse those who relied or could qualify for bringing a claim on the basis of these projections. All right, so this is a transfer, a particular kind of transfer, not one necessarily that we think is desirable. And it didn't take long, as you saw in the readings, just about 10 years, for the SEC to put an end to the kind of liability that could arise from Beecher v. Abel. And so you saw the safe harbor rule, which ended up getting promulgated as Rule 175, basically gave companies like Douglas here an assurance that their shareholders or their residual claimants down the line would not be on the hook to reimburse those shareholders who relied on the projection. And so Rule 175 basically provides that a forward-looking statement of any kind, and there are certain definitions, we'll look together at this has actually been subsequently codified in Section 27A. You should have that in your, well, let's just look at it together. Rule 175 was subsequently codified. Let's see, the 1933 Act. This is how easy it is to find it. So let's look 27A. Here we go. So Section 27A, application of safe harbor for forward-looking statements. This is a codification of Rule 175 by and large. And what Section C provides is that except as provided in subsection B, in any private action, okay, it applies here to private actions, that is civil liability by private plaintiffs, arising under this title that is based on an untrue statement of a material fact or omission of a material fact necessary to make the statement not misleading, a person referred to in subsection A shall not be liable with respect to any forward-looking statement, whether written or oral, if and to the extent that, and the main requirement here is that the forward-looking statement has to be accompanied by meaningful cautionary statements identifying important factors that could cause the actual results to differ materially from those in the forward-looking statement. So the law for forward-looking statements is given to us in the 1933 Act in Section 27A. It's an analogous provision in the 1934 Act. The key thing to realize is that the challenge with forward-looking statements is separating what is considered part of the statement, that part of the basis for the statement at the time it was made, as opposed to something in the future that occurred that nonetheless should be disclosed to investors. We're going to look tomorrow at this problem in much more detail, but for now I just want to talk a little bit about the Wielgos case before we wrap up, which kind of teases this out a little bit. So we could say Commonwealth Edison, written by Professor and then Judge Frank Easterbrook. I'm just going to run quickly through the facts because of time. Basically, we have a utility company, Commonwealth Edison, who is relying on what kind of power plants do they operate? Nuclear reactors. And they are an electric utility firm that registers its securities on what kind of form? Who remembers? S3. What is S3? S3 is a shelf registration statement. We learned this in the Section 5 lecture. We said that Form S3 is used by firms that are already publicly traded, that want to have an accelerated registration and sale process. In particular, what a shelf registration, just to review, allows you to do is to put the registration statement out today, and then at some point in the future, actually offer your securities for sale on the basis of that registration statement that you filed today. Now, the time gap between the moment you register the securities on the registration statement and when you begin to sell those securities raises some really fun questions, I think, around what it means to update your investors with new information. One point to realize is that liability, and we'll again talk about liability in detail next week, but liability for misstatements that are made attaches to statements made in the prospectus or omissions from the prospectus that are misleading, right? That is, they're necessary to make something you said not misleading. Now, this is the point that is at the center of Commonwealth Edison. What the parties are arguing over is the fact that nuclear power became more expensive and took longer to build these plants from the time that the prospectus was issued, filed, and the time that the securities were sold. So the question that's teed up by this case is whether a forward-looking statement about the estimated profitability of Commonwealth Edison, the implied costs and revenues, were misleading at the time because the firm knew before selling the shares, even though it didn't know at the time the registration statement was filed, but before selling the shares, the firm knew that, in fact, nuclear power had become more expensive and there were greater delays. You see this on the bottom of, it's page 154 of the reader, the bottom page numbers. The statements incorporated into the prospectus were erroneous, not only in the sense that they turned out to be inaccurate, which is the Beecher v. Abel kind of setting that we would find very troubling, but, as Easterbrook points out, also in the sense that by early December 1983, when it sold the stock, Commonwealth Edison's internal cost estimates exceeded those in the documents on file. So what does Easterbrook, for those of you who read Commonwealth Edison, what does Easterbrook find? Does he find that, in fact, that error in the prospectus, he says, a material error in the prospectus usually is enough for liability. What does Easterbrook conclude? Does he conclude that the fact that they sold the securities on the basis of, well, let's say, while knowing that costs for nuclear power were higher at the time, does that lead Easterbrook to conclude that Commonwealth Edison is liable? Who can tell me what he decides for Commonwealth Edison? Are they liable or not? For not revealing the higher cost estimates. Yes. Off here. Bazina. Yes. Bo. Yes.
So he says
Bo.
that they're not liable because anyone who is paying attention to the law should have known that these costs would come up.
Yeah. So on the, that's right. So he says that, well, on 154, no one has to, towards the top of the page, no one has to read the fine print of a Form 10K to recognize that these are facts of life. That's right, although it's not technically the basis. It's true, but there is a more technical basis for his finding. Can anyone, yeah, go ahead. Yeah, that's part of it, but there's something in particular. He points to the language of Rule 175 at the time. Davia? Yeah, but that's true too, but he's looking for, he cites something in particular. Caitlin, is that your hand? Yeah. Exactly. Exactly. Excellent. Caitlin, well done. So Caitlin points out that the statute, the rule at the time, requires that the plaintiff show that the statement did not have a reasonable basis or was not made in good faith. That's what I was looking for. That's the language of the rule. Remember, always start with the language of the rule. And then the question is, okay, so did Commonwealth Edison have a reasonable basis? So there's this great paragraph. I was just like so excited I got to read this to you on 156 in the middle of the page. You're going to love this. Commonwealth Edison made point estimates. Byron 1 and 2 will cost $3.34 billion and start in 1984 and 85. Everyone understands the point estimates are almost certainly wrong. Things will not go exactly as predicted, and any deviation will cause the future to diverge from the estimate. Statisticians and stock analysts need confidence intervals to go with the maximum likelihood estimate. Does anyone know what he means by that? Has anyone done stats? Yes, a few of you. That's great. Don't worry. Commonwealth Edison might have said, for example, here we go. This should sound familiar. There's a 2/3 chance that the cost will fall in a given range, identifying the events that would push the cost up or down within or outside of that range. So he wants 9 and 11, right? He wants a 1/3 chance. Okay, never mind. So there's Easterbrook and I are on the same page. And he points out, though, that Commonwealth Edison did not do this. That being said, Easterbrook points out as well that while Commonwealth Edison did not give the probabilities that the forecast was accurate, the law doesn't require a firm to give those probabilities. At the end of that page, he points out that Commonwealth Edison made a projection but did not disclose data, assumptions, or methods. The cautions accompanying the projections were so much boilerplate, no one could have deduced from the cloud of legalese how much uncertainty the firm perceived. Okay, but he says Rule 175 does not require a firm to reveal its assumptions. Commonwealth Edison did not need to tell the market anything more, essentially. Didn't need to tell the market the assumptions on the basis for which it reached those conclusions. In fact, he goes on to say, if Commonwealth Edison were doing significantly and unexpectedly worse than the industry as a whole, that might signal the presence of important firm-specific information that it would have to reveal, Wielgos does not contend that either the estimate or the performance of Commonwealth Edison fell substantially below the norms of the industry. And here, my friends, is a great gem from the Seventh Circuit. Half of all firms do worse than the average. Does everyone? Yeah. What is it with lawyers and math? All right, for those of you who haven't quite got... half of all firms do worse than the median. That's what the median is. It's the halfway point. Okay. Finishing in the lower half does not imply a it must have been a clerk who wrote that, right? I don't know. So I don't know, those Chicago students. Finishing in so they didn't have your kind of SecReg class, right? That's where this kind of stuff comes from. Okay. Finishing in the lower half does not imply a securities problem, but Wielgos does not suggest. Okay. So the point he makes is, look, the estimates in question have a reasonable basis. Issuers need not reveal all projections. There didn't seem to be that there was anything unusual like finishing below the average or in the bottom half. And so Easterbrook concludes, look, you don't need to tell the market what your assumptions are. You don't need to tell the safe harbor is designed to allow you to make a projection about the future and to be silent after that. So what we'll really think about tomorrow is what we will take this back a little bit to economic theory and say, like, why is it a good idea to allow forward-looking statements? But I want you to think, this part of the course, this particular topic is more about the technical distinction between whether you are updating the market about something that changed your assumptions that led to the projection, or whether you are updating the market about some kind of new information that has arisen. And this distinction between a duty to update versus a duty to correct, you saw in the readings, is really the key distinction in this area. As with all key distinctions, it's often unclear whether or not new information changed the assumptions on which you based your forecast. And thus, you're correcting something misleading about that forecast. And even if you can get out of the safe, even if you're sort of out of the safe harbor for one reason or another, or if, in fact, you have some affirmative duty to disclose a new fact because it had nothing to do with your projection. Notice that distinction can make all the difference. If the safe harbor applies, it only applies to your forward-looking statement. So it could be that there's a basis for requiring you to disclose something more that was outside the scope of the safe harbor precisely because it did not involve the assumptions or the kind of information that led to your projection, but rather was a subsequent event. So the distinction between these two can matter in both of those ways. Just to reiterate, one, it could be that you, for some reason, have a duty to correct a misleading statement you made that led to your projection, or that was part of your projection. That may or may not be governed by the safe harbor, depending on whether the safe harbor applies. So that's question one. And question two is, even if the safe harbor applies, could you nonetheless be required to disclose that new fact to the market because precisely because it doesn't fall within the scope of your forward-looking statement? So this can kind of be played either way. And what do we do when something can be played either way? We try to think of a rationale for why we want firms giving updates. All right? And so that's really the question I'd ask you to kind of take into the reading tonight as you re-look at it one more time and into the conversation tomorrow, is this distinction between updating and correcting between a forward-looking statement and some new fact, again, comes back to the tension between informed trading and disclosure. Center for Japanese Legal Studies is having an event, just to remind you, a really cool lunch talk on the law and economics of Japan. You're more than welcome to go. I will see you tomorrow morning. $5.46 for that lunch. Hi, Divya.
negligence, it is simply the state has to prove negligence. If he makes a negligent mistake, an honest mistake, it's irrelevant because the state doesn't have to prove that that he knew or that he had so an honest mistake that is let's say as in a case like Green, the defendant's making an honest mistake, but it's really a civil mistake, and most people would know those are not the case. Okay, so if that's the case, and all the prosecutor has to do is negligence, then that honest mistake, which is good as a defense to specific isn't really relevant.
You see? Okay, so how about the audio? Check 1, 2, 1, 2, 3, 4. Can you hear me?
It's not a defense.
Oh, okay, so now what you can do, right? You have to disconnect the podium microphone.